Karen Delaney's voice was cold and absolute. Your fence isn't on the approved materials list. 30 days to comply, or $500 per day in fines. It's like a clipboard could erase what the deed had proven since 1967. Like proximity could override the fact that I'd only leased development rights under specific conditions. What she didn't know, I had the ground lease showing her developer built 652 homes when I authorized. 650. The recordings proving the HOA was never granted authority over my parcel, and 12 payment defaults that voided the entire agreement. 652 homes on 235 acres. My family owned for 60 years. An HOA threatening to block my driveway using authority she never had. A developer who exceeded approved density hoping I'd never check the PLAT. Karen made the mistake every HOA president makes, assuming the quiet landowner who'd signed a 99-year lease would be too intimidated to hire a title attorney. She assumed wrong. This is the story of how an HOA president lost her position and a developer paid $150,000 because neither could answer one question. HOA hold title to this land? Because property law doesn't care about covenants. It cares whose name is on the deed. But let me start from the beginning. Before we dive into, I'd love to know where you're listening from today. And don't forget to hit the like and subscribe buttons for more interesting stories just like this. I was replacing a section of fence when the white SUV pulled up. Karen Delaney stepped out, clipboard in one hand, phone in the other, heels sinking slightly into the dirt road that had been gravel when my grandfather was alive. Mr. Hawthorne, she called. That fence isn't on the approved materials list. I set down the post hole digger. I'm not subject to your materials list. Your property borders HOA common areas, she said, like she was explaining arithmetic to a child. Section 14.3 of our covenants requires aesthetic compliance for all properties within the master plan overlay zone. I'm not part of your HOA, I said slowly. She handed me a letter, official letterhead, reference codes, legal language. 30 days to comply, Karen said, or $500 per day in fines. I stared at the paper, then at the gates behind. Her the entrance to Maplewood Heights, 650-home subdivision, built on land my family had owned for 60 years, land I'd thought I still owned. You can't find me, I said. That's a matter of interpretation, she smiled. I suggest you review your development agreements more carefully. She drove off, and I stood there holding a violation notice for a fence on my own property, wondering when exactly I'd lost control. I inherited 240 acres from my grandfather. When I was 31, he'd bought it in 1967. With money saved from 3 decades working freight at the rail yard, raised cattle on it, grew hay, taught me to drive on the dirt roads that crisscross the pastures. This land'll take care of you, he used to say, standing on the hill at sunset, if you take care of it. By the time it became mine, the city had crept 15 miles closer. The county kept reassessing property taxes based on development potential instead of what it actually was. Overgrown fields and a homestead that needed a new roof. The taxes tripled in 6 years. I kept my job in the city, drove out on weekends. To mow and pretend I had a plan, I didn't. Selling meant losing the last piece of family history I had. Keeping it meant going broke. Marcus Webb found me before I found a solution. Pressed khakis, expensive watch, Land Rover that had never seen mud. He showed up on a Saturday with a folder and a pitch. Partner with us, not sell to us. Long-term ground lease, he explained. 99 years. We build a master-planned community, 650 homes. Amenities, the works. You keep the deed. We handle everything. You get lease payments plus a percentage of sales. It sounded clean. I'd keep ownership. They'd take the risk. I hired a lawyer. Family friend who did wills and small contracts. He skimmed the documents, said they looked reasonable. Admitted development law wasn't his specialty. I should have heard the warning in that instead. You keep the deed. Worst case, the lease ends and you get the land back. I signed in February. Marcus shook my hand. You won't regret this. I moved into the homestead full-time and watched the crews arrive. The first time a bulldozer carved through the south pasture. I felt something crack in my chest. That's where my grandfather used to move the cattle in summer. I'd spent a dozen childhood afternoons riding fence line with him, just listening to him talk about soil quality and water flow and how you had to think in generations, not quarters. Now it was a grid, stakes every 50 feet, surveyors marking lots. Told myself it was progress that he would have understood, but keeping the deed meant I was honoring his work, not erasing it. I didn't believe it, but I cashed the checks anyway. Within 18 months, 200 homes stood where pasture used to be, concrete driveways over dirt my grandfather had walked, decorative trees planted in neat rows where oaks had grown wild for decades. They called it Maplewood Heights. The marketing promised, live the life you deserve. Wondered what my grandfather would have called it. The HOA formed during Phase 2. Marcus had mentioned it early on. Every community needs one. Keeps values stable, handles maintenance, but I hadn't paid attention. I wasn't part of it. My Favaker homestead parcel was excluded from the covenants. At first, the rules were reasonable. Lawn care, trash schedules, noise limits after 10 p.m., then they got specific. A neighbor got fined for parking his work van in the driveway overnight. Another for a flagpole installed without board approval. Someone else repainted their shutters after the HOA, said the original color was too bold. I'd hear complaints at the hardware store. People frustrated but resigned. That's HOA life. They'd say, like it was weather. The woman running it, Karen Delaney, had been elected president twice. She took the job seriously, maybe too seriously. She visited me once during Phase 3, concerned about my rustic property being visible from the subdivision streets. Your barn needs paint, she said. Your truck doesn't align with our aesthetic. This was here first, I said. I'm sure we can work something out. She smiled. It didn't reach her eyes. I closed the door. The problems started small. My lease payments were late. Once in month 14, again in month 18. I called Marcus. He didn't call back for 3 days. When he did, he was vague. Cash flow timing. Construction costs ran over. You'll get it. I did. A week late. Then 2 weeks. I told myself it was normal. Big projects had moving parts. I should have pushed harder. Instead, I watched Phase 4 go up, and 5, then 6, 650 homes total. A clubhouse, 2 pools, walking trails with decorative lights. The HOA budget hit 6 figures. They hired a management company, installed cameras at the gates. Karen ran unopposed for her 3rd term, and the letters started arriving. Not from Karen directly, from Maplewood Heights HOA, Office of Community Standards. Complaints about noise, claims my fence violated setbacks, demands I submit to voluntary design review. Ignored them. I wasn't part of the HOA. Then came the letter about the fence, Karen's visit, her clipboard, her certainty, master plan overlay zone. I went inside and pulled out the box I'd shoved in the closet 2 years ago. The development agreements, the lease, the legal exhibits I'd signed without reading past page 12. It took me an hour to find it. Exhibit E, Section 7, subsection. See all parcels within the designated master plan boundary, including any retained landowner parcels, shall be subject to applicable design standards and aesthetic covenants as established by the community association or its designee. My hands went cold. I flipped to the boundary map. My 5-Gare homestead marked in blue. It's excluded from HOA governance, sat inside a red dotted line labeled Master Plan Overlay District. 2 different zones, 2 different rules. I'd kept the deed, but I'd signed away more control than I understood, and Karen Delaney, armed with covenants and a lawyer, was about to teach me exactly how much. The second letter arrived 4 days later, not about the fence this time. About my truck, dear Mr. Hawthorne, it has come to the attention of the Maplewood Heights HOA. Gored that a commercial vehicle is regularly parked on your property in clear view of Willow Creek Lane in Maple Ridge Court. Per master plan design, standard section 9.2. Commercial vehicles over 3/4 ton capacity are prohibited from overnight parking in residential view corridors. I read it twice, standing at my mailbox. My truck was a 3/4-ton pickup. 15 years old, I used it to haul lumber and feed. It sat in my driveway on my property like it had for 2 years. I called the number at the bottom of the letter. A receptionist answered, Maplewood Heights HOA Management. How may I direct your call? Karen Delaney, I said. Ms. Delaney's in a board meeting. May I take a message? Tell her, James Hawthorne called. Tell her I'm not moving my truck. I'll pass that along. Sir? She hung up. The third letter came a week later. Certified mail. Continued violations property at 14 Old Farm Road. It listed 5 items. Unpermitted fence construction still ongoing, commercial vehicle and residential view corridor. Exterior paint color on barn, structure overgrown vegetation. Along shared property boundary, encroachment of gravel access road onto HOA maintained easement. Last one stopped me cold. My driveway, the same gravel road my grandfather had driven for 50 years, was now an encroachment. Onto HOA maintained easement. I pulled out the development agreements again, found the easement map. There it was. A 20-foot utility and access easement running along the eastern edge of my property. It connected to the subdivision's internal road network and provided secondary access to a retention pond the HOA maintained. The easement predated the subdivision. It had been part of the original ground lease necessary for utility access during construction, but the language was vague. Landowner grants developer and community association perpetual easement for access, utilities, and maintenance purposes. Perpetual. I stared at the word. That wasn't temporary construction access. That was forever. And according to the letter, my gravel driveway, which crossed the easement at 2 points, was now a violation of easement terms. Because I hadn't gotten approval from the HOA before altering the access corridor. I hadn't altered anything. The driveway had been there since 1973. I drove to the HOA office the next morning. It was located in the clubhouse near the main gates, a building with stone veneer and decorative columns that sat on what used to be the hill where my grandfather watched sunsets. The receptionist smiled politely. Do you have an appointment? No, I need to speak with Karen Delaney. Ms. Delaney is with residents right now. If you'd like to leave a message, I'll wait. I sat in the lobby for 40 minutes, watched people come and go. Residents complaining about pool hours, asking about tennis court reservations, submitting requests for fence approvals, everyone treating the HOA like it was a municipal government. Finally, Karen emerged from a conference room. She saw me and stopped. Mr. Hawthorne, I didn't realize you had an appointment. I don't. I stood, holding the certified letter. We need to talk about this. She glanced at the letter, then gestured to her office. 5 minutes. We sat across from each other. Her desk was immaculate. Framed photos of the subdivision, plaque, Community Excellence Award, 2024. Your latest letter claims my driveway is encroaching on your easement, I said. That driveway's been there for 50 years. The easement terms require approval for any structures or improvements within the 20-foot corridor, Karen said. Your driveway crosses that corridor without documented approval. It existed before. Your HOA existed. Easement predates our incorporation, yes, but enforcement authority transferred to the HOA upon formation. That's standard in master plan developments. So you're claiming jurisdiction over a road that was here before your subdivision was even designed. Karen folded her hands. Mr. Hawthorne, I understand you have an emotional attachment to this property, but the reality is that Maplewood Heights is now a community of 650 families. Property values here exceed $70 million. Our residents expect certain standards. The residents are living on my land, I said. Her smile tightened. They're living on land leased to Crestwood Development Group under a 99-year agreement. The HOA holds certain rights under that agreement, including enforcement of design standards and easement protections. I'm not part of your HOA. You're within the master plan boundary, she said, which makes you subject to overlay provisions. We've been through this. So you're saying you control my property? I'm saying we have the authority to enforce standards that protect property values for 650 families, Karen said. If you're unwilling to comply voluntarily, will pursue enforcement through appropriate channels. What does that mean? She stood. It means our legal counsel will be sending you a formal notice. I suggest you consult an attorney. The lawyer's letter arrived 8 days later. It was 7 pages long. It's typed on heavy letterhead. Whitmore and Associates, attorneys at law. Dear Mr. Hawthorne, this firm represents Maplewood Heights Homeowners Association, Inc. Association regarding ongoing violations of master plan design standards and easement encroachments on property located at 14 Old Farm Road. Cited sections of the development agreement I'd never read closely. Claimed. The HOA had successor enforcement authority over design standards. Asserted that my driveway, fence, and truck violated recorded covenants. Then came the threat. Should you fail to remedy the above violations within 30 days, the association will pursue all available remedies, including injunctive relief, monetary damages, and costs of enforcement, including attorney fees. Additionally, the association reserves the right to restrict or terminate access via encroaching improvements on association-controlled easements. I read that last sentence 3 times. They were threatening to block my driveway, the only access. Road to my house. I hired a lawyer that afternoon, not the family friend who'd reviewed the original deal. A real estate attorney named Catherine Marsh, who'd handled a property dispute for a colleague 2 years earlier. I brought her everything. The ground lease, the development agreements, the easement maps, every letter from the HOA, and the demand. A letter from Whitmore and Associates. She spread them across her conference table and spent 90 minutes reading in silence. Finally, she looked up. "This is a mess," she said. "How bad?" "You retained title to the land, which is good. But you also granted the developer, and by extension, the HOA extensive rights, easements, design authority, enforcement mechanisms. Some of this language is incredibly broad. Can they block my driveway?" "They can try," Catherine said. "Whether they'd succeed depends on how a court interprets these easement provisions. But litigation is expensive and slow. They know that. So what do?" She tapped the development agreement. "First, we need to understand exactly what you signed. There are layers here: ground, lease terms, HOA covenants, easement grants, overlay provisions. Some of these documents reference others in the hierarchy. Isn't clear meaning the HOA thinks they have total control? You think you retained autonomy? The truth is probably somewhere in between. But here's the thing." She pulled out the easement map. "This easement language is odd." "How so?" "It grants perpetual access and maintenance rights, but it doesn't explicitly transfer enforcement authority to the HOA. That might have required a separate recorded instrument. If it's not properly documented, their claim to control your driveway could be invalid." I felt something loosen in my chest. So they're bluffing. Maybe there's a document we haven't seen yet. She made a note. "I'll send a records request to the county, see what's actually on file. In the meantime, don't comply with their demands, but don't escalate either. Just hold your ground. That's it. For now." She closed the file. "Mr. Hawthorne, this is going to get complicated. The HOA has resources, and they're used to people backing down. You need to be prepared for a fight. I thought about my grandfather, about the way he'd stand on the hill and look out over land he'd bought with his own hands. I'm prepared," I said. I drove home and walked the property line. The fence I'd been building, the barn that needed paint, the gravel driveway that had been there longer than anyone in Maplewood Heights had been alive, through the trees. I could see the subdivision, streetlights coming on, families pulling into driveways, kids playing in yards that used to be pasture. 650 homes, all built on land my family had owned for 60 years. Land, I'd thought, I was protecting by keeping the deed. But standing there, holding a lawyer's threat letter, I realized something I should have understood 2 years ago when I signed Marcus Webb's deal. Ownership without control is just a title on paper, and the HOA was betting. I'd figured that out too late to do anything about it. They were wrong. Catherine called on. A Thursday morning, 3 weeks after I'd hired her. "I need you to come to my office." "Now, what did you find?" 652. "What?" Just get here. I sat across from her desk 30 minutes later. She had county plat maps spread across the conference table, highlighted in yellow and red. Your ground lease authorized development of 650 residential units, Catherine said. She pointed to the original site plan, dated and signed by both me and Marcus Webb. Maximum density, explicitly approved. Right here, okay? She slid the final. Recorded plat, forward. They built 652. I looked at the map, then at her. You're sure? I counted 3 times. 2 small lots on the eastern boundary, added during Phase 6. They're not on your approved site plan. My hands went cold. Marcus built 2 extra houses. Crestwood Development built to unauthorized units in violation of your lease, Catherine said. Section 12 of your agreement states that exceeding approved density constitutes material breach, giving you the right to terminate the lease and reclaim all development rights to the whole property, all 235 leased acres, with 652 homes. Sitting on it, I stood up, walked to the window, stared at nothing. 2 houses, 2 extra houses, and Marcus had just handed me a nuclear option. He knew, I said quietly. He had to know. You don't accidentally build 2 entire houses. Probably a revenue decision, Catherine said. 2 more. Lots, 2 more sales. Maybe he thought you'd never notice. He thought I was stupid. My voice sounded strange. Flat. Thought I'd just cash the checks and never look at the plat. Most people would. I turned around. Can I void the whole lease? Actually do it? Catherine hesitated. Legally? Yes, you have grounds, practically. Court would have to weigh your contract rights against the chaos of unwinding a 650-home subdivision. Judges hate outcomes that hurt innocent third parties. The homeowners. The homeowners bought in good faith. They'd keep their lots. Individual deeds are secure, but everything else would be in question. Streets, common areas, HOA authority. It would be years of litigation, but the HOA's authority would be gone. The underlying lease is void, yes? Your power comes from that lease. No lease, no legal foundation. I felt something sharp and hot rising in my chest. Not quite anger, something colder. I need to talk to Marcus. I called him from the parking lot. It rang 4 times before he picked up. James, been a while. We need to meet. I'm actually in the middle of you built 652 homes on my land. Silence. The lease authorized 650, I continued. But Section 12 says exceeding approved density is a material breach, so we need to talk today. In Denver until next week, then we'll talk when you get back. But we're talking Marcus. In person? I hung up. He showed up at my house 6 days later. Same Land Rover, same expensive watch. But the smile was gone. We sat on my porch. He didn't ask to go inside. The 2 lots on the eastern boundary were added during final engineering, Marcus said. Grading adjustments created buildable space we hadn't anticipated. We saw an opportunity. You saw a chance to make more money off my land without telling me. It was 2 lots, James. In a 650-home development. Statistically insignificant, contractually catastrophic, I said. You violated the lease, which means I can terminate it. Marcus's jaw tightened. You want to play that card? Fine. Let's talk about what happens next. You terminate the lease, we go to court. The judge sees 652 families living in a stable neighborhood, and you asking to blow it up over 2 houses? How do you think that plays? I think it plays like you breached a contract and got caught. I think it plays like a landowner trying to extort a developer after taking millions in lease payments. Marcus leaned forward. You signed that deal, James. You cashed every check. You don't get to retroactively decide it was unfair. I cashed late checks, I said. 12 payments more than 30 days overdue. 4 payments you missed entirely. His face went carefully blank. My lawyer pulled the records, I said. The lease requires payment within 15 days. After 30 days, it's a default. You're in breach on 2 fronts, Marcus. Construction and payment. He was quiet for a long time. What do you want? He finally asked. I want the HOA off my back. I want Karen Delaney and her lawyers to stop threatening me over a fence and a truck on my own land. That's not my problem. You made it my problem when you gave them enforcement authority they don't legally. Have I said? The HOA's power comes from your lease. Your lease is void, which means they have no authority over my property. So either you fix it, or I file to terminate and we let a judge sort it out. Marcus stood. You're making a mistake. You made it. First, he walked to his Land Rover, then stopped, turned back. You really want to go to war over this? He asked. It'll cost you everything. Legal fees you can't afford. Years of your life. And at the end, you might lose anyway. Or I might win, I said, and get my land back. He shook his head. You never lost it, James. You just didn't read what you signed. He drove away. I sat there, watching the dust settle on the gravel road. He was right about one thing. I hadn't read carefully enough, but wrong about the other. I was absolutely willing to go to war. The code enforcement inspector came the next afternoon. Middle-aged guy, clipboard, county truck. He walked the property, took photos, asked questions about the barn. When was this structure built? 1980? My grandfather built it. It's listed as agricultural on the tax rolls. No, because it was agricultural. Now it's storage. He made notes. Complaint says you're living in it. I'm living in the house. I pointed to the homestead. It's the same house my grandfather lived in. Been residential since 1973. He checked the barn. Empty except for tools and lawn equipment. No bedroom. No kitchen. No bathroom. Looks fine to me, he said. I'll file the report. Complaint was unfounded. Can you tell me who filed it? He hesitated. Came through HOA management company, Maplewood Heights. Thought it was anonymous. Complaint is. Source isn't. If we need follow-up. He closed his folder. You're clear, Mr. Hawthorne. Sorry for the trouble. Watched him drive away, then added it to my timeline. Day 25. Code. Enforcement complaint filed by HOA. Day 32. Inspector clears property. Complaint unfounded. Day 33. Marcus confirms lease breaches. Refuses to fix HOA problem. I was documenting everything now. Not just for Catherine. For me. Because I needed to see it written down. Needed proof that this wasn't paranoia or overreaction. The HOA had threatened my driveway. Filed false code complaints. Claimed authority they didn't have. And Marcus had. Built his empire on land he'd never properly secured. Every letter. Every email. Every date and detail. I photographed the property. The fence. The barn. The truck. The boundary markers. I requested every recorded document related to Maplewood Heights from the county at night. I sat at my grandfather's old kitchen table and organized it all into a binder that grew thicker every day. It felt like the only thing I could control. Catherine called 2 weeks later. I have the complaint drafted. Declaratory judgment action. We're asking the court to clarify rights under the lease. Declare the HOA's enforcement actions void. Determine whether lease termination is warranted based on material breaches. How much will this cost? Filing fee is $500. A retainer is $15,000 to start. If it goes to trial, could be $50,000 to $75,000 total. My stomach dropped. I don't have that.
Ow!
You could borrow against the property. I'm not mortgaging my grandfather's land to fight a lawsuit. Silence on the line. Then we negotiate, Catherine said quietly. We use the threat of filing to force a settlement. Make them understand what we found, what we could do, and what they have to lose. And if they call the bluff, then you have to decide if you're willing to walk away. I looked out the window. The subdivision lights were coming on. Families coming home. Kids playing in yards. 652 homes built on land that was supposed to stay in my family. If I lose, I asked, you could? Court might rule the breaches aren't material enough to void the lease. Might impose penalties on Crestwood but leave the structure intact. Might decide the HOA's authority is valid despite the recording gaps. Litigation is unpredictable. If I don't file, they win by default. Yes. I thought about Karen's smile, Marcos's arrogance, the lawyer's letter threatening to block my driveway. I thought about my grandfather, standing on the hill, saying the land would take care of me if I took care of it. File it, I said. James, file it. I'll find the money. No going back. This becomes public record. Every homeowner will know. The HOA will fight. Marcus will fight. It's going to be brutal. It's already brutal, I said. I'm just making it official. The complaint was filed on a Monday morning. James Hawthorne v. Crestwood Development Group, LLC and Maplewood Heights Homeowners Association, Inc. Declaratory judgment, breach of contract. Quiet title Catherine served. Crestwood by certified mail. Served the HOA through their registered agent. By Wednesday afternoon, my phone started ringing. Marcus's lawyer. The HOA's lawyer, a reporter from the local paper who'd seen the filing. I didn't answer. I sat on my porch, watching the sun set over land my grandfather had bought 60 years ago. Land I'd almost lost by trusting the wrong people. Land I was now fighting to keep. The deed had my name on it, and I was about to make damn sure everyone remembered that. The HOA's response arrived. 11 days after we filed, Catherine called me at 7 in the morning. You need to see this. I drove to her office. She had the filing pulled up on her computer, 43 pages. They're asking the court to dismiss with prejudice and sanction you for filing a frivolous lawsuit, she said. They're also counterclaiming for harassment, abuse of process, and requesting a restraining order to prevent you from interfering with HOA operations. Interfering how? She scrolled down. They claim you've been photographing residents, trespassing on common areas to measure boundaries, and intimidating board members. I walked my own property line. They're saying you crossed onto HOA land. She pointed to an attached photo of me standing near the retention pond with a measuring tape. Recognize this? I did. I'd been checking whether my property marker was accurate. The pond sat partially on the easement they claimed to control. They had someone watching me, I said. They have 4 affidavits. Karen Delaney, 2 board members, a homeowner who says you confronted her while she was walking her dog near your fence. I said good morning. She says you told her the HOA was illegally controlling land that belonged to you and that she should be concerned about her property rights. I had said that because it was true. This is retaliation, I said. Of course it is, Catherine replied, but it's also strategy. They're trying to make you the problem. Shift focus from their breaches to your behavior. And she scrolled to the last page. They're asking for attorney fees. $75,000 if they win. My chest went tight. I don't have $75,000. Then we need to be very careful, Catherine said. Because if we lose, you could lose the land trying to defend it. The first hearing was scheduled 3 weeks later. It was procedural arguments on the motion to dismiss, but the courtroom was packed. Homeowners filled the gallery. I recognized faces from the neighborhood. People I'd waved to. People who probably had no idea what this case was really about. Karen sat in the front row behind the HOA's legal team. 3 lawyers from Whitmore and Associates. Expensive suits, matching briefcases. Catherine and I sat alone at our table. Judge Maria Sandoval presided. Late 50s, sharp eyes. Reputation for not tolerating games. The HOA's lead attorney, a man named Richard Whitmore, stood first. Your Honor, this lawsuit is a transparent attempt by the plaintiff to escape contractual obligations he voluntarily entered. Mr. Hawthorne signed a 99-year ground lease, accepted millions in payments, and now seeks to void that agreement over trivial technical violations. 2 unauthorized homes and 12 late payments aren't trivial, Catherine said. Counsel will have her turn, Judge Sandoval said. Whitmore continued. The plaintiff claims the HOA has no authority over his property, but he ignores the master plan overlay provisions he agreed to. He ignores the easement rights properly recorded, and he ignores the fact that 652 families have built their lives on this land in reliance on valid agreements. Mr. Whitmore, the judge interrupted, does the HOA hold title to the underlying land? He hesitated. The association holds certain rights and interests derived from the ground lease. That's not what I asked. Does the HOA hold recorded title to the 235 acres in question? The association operates as the de facto governing body for the community. Built on those acres, Counselor. Judge Sandoval leaned forward. It's a yes or no question. Whitmore's jaw tightened. No, Your Honor. The deed remains in Mr. Hawthorne's name. But the lease conveys. We'll get to what the lease conveys, the judge said. She turned to Catherine. Ms. Marsh, your response? Catherine stood. Your Honor, this case is about what happens when a developer and an HOA overreach the authority they were given. Mr. Hawthorne retained title to his land. He granted limited development rights under specific conditions. Those conditions were violated. HOA now claims powers. It was never properly granted. We're asking the court to clarify those rights before my client is forced off his own property. The plaintiff isn't being forced anywhere, Whitmore objected. He's manufacturing a crisis to escape a contract he regrets signing. He regrets trusting people who built 2 unauthorized homes and then pretended they had the right to control his driveway. Catherine shot back. Judge Sandoval raised a hand. I'm denying the motion to dismiss. The courtroom stirred. This case raises genuine questions about the scope of authority conveyed under these agreements, the judge continued. I'm ordering full discovery. Both sides will produce all documents related to the ground lease, HOA formation, covenant recordings, and title transfers. I'm also appointing a special master to review the title chain and report findings. Whitmore stood. Your Honor, that's unnecessary. It's necessary if the association is claiming authority over land it doesn't own, Judge Sandoval said. Discovery deadline is 60 days. Special master will be selected within 2 weeks. Anything else? Catherine glanced at me, then stood. Your Honor, given the HOA's counterclaim and their pattern of escalating enforcement actions, we'd ask the court to issue a temporary restraining order preventing further violations, notices, or fines against Mr. Hawthorne pending resolution. Objection, Whitmore said. The association has every right to enforce valid covenants. You'll have a chance to prove they're valid, Judge Sandoval said. Until then, the association is restrained from issuing fines or violation notices to the plaintiff. Related to his retained parcel, Mr. Hawthorne, that doesn't mean you can ignore legitimate concerns. Build your fence properly. Keep your property maintained. But Ms. Delaney, she looked directly at Karen. You will not be sending any more letters until this court determines who actually has enforcement authority. Clear. Karen's face went white. She nodded. We'll reconvene after discovery, the judge said. Court adjourned. The special master was a title attorney named Douglas Kim, 62 years old, 30 years experience. No patience for incomplete paperwork. He requested documents from all parties. Me, Crestwood, the HOA, and the county recorder. Then he started digging. Catherine and I met with him 6 weeks later at his office. He had 3 banker's boxes of files and a 20-page preliminary report. Your lease is valid, he said, looking at me. Properly executed, properly recorded. Crestwood had the right to develop 650 residential units per the approved site plan, but they built 652, I said. Correct, which constitutes breach. He pulled out the final plat. More concerning is what happened after construction. The HOA was formed, covenants were recorded, but he slid a document forward. The Declaration of Covenants transfers enforcement authority only over platted lots within the subdivision, not over your retained parcel, so the overlay language exists. In your private lease with Crestwood, Kim said. But it was never recorded as a covenant running with your land, which means it's not binding on you or enforceable by the HOA. Catherine leaned forward. So they've been threatening him with authority they don't legally have. Appears so, Kim said. There's more. The easement along Mr. Hawthorne's eastern boundary, the one the HOA claims gives them control over his driveway, was granted for specific utility and maintenance purposes, not general access control, certainly not enforcement of aesthetic standards. They threatened to block my driveway, I said. They can't, Kim said flatly. The easement doesn't give them that right. He turned to another section. I also reviewed the HOA's financial records as part of the title chain analysis. You requested this, Ms. Marsh? The court ordered full financial disclosure, Catherine said. Good, Kim said. Because there are irregularities. He opened a spreadsheet. The HOA has paid approximately $340,000 to a property management company. Called Summit Community Services over the past 3 years? That's their management company, Catherine said. Owned by Karen Deloney's husband, Kim said. The room went silent. The contract was approved by the board, Kim continued, but Mrs. Delaney voted on it. That's a conflict of interest under state HOA law, which requires recusal. More concerning. He showed us another page. Summit's contract bills at nearly twice the market rate for communities this size. Self-dealing, Catherine said. At minimum, improper contracting, Kim agreed. There's also evidence of selective enforcement. Properties owned by board members have received 0 violation notices in 3 years. Properties owned by non-board members average 4.7 violations each. I thought about the letters I'd gotten, the threats. Karen's certainty that she had the power to fine me. She was running it like her personal fiefdom, I said. She was running it in violation of state law, Kim corrected, which is relevant to this court's analysis of whether the omitted actions have been lawful and whether you're entitled to relief. The findings went into Kim's official report to the court. Whitmore tried to have sections excluded, argued the financial issues were irrelevant to the title dispute, but Judge Sandoval disagreed. If the association has been operating outside statutory requirements, that bears on whether their claimed authority should be recognized, she said during a conference. Call the Special Master's Report stands. The report became public record. Within 48 hours, the local paper ran a story. HOA president's husband paid $340,000 in contracts. Conflict questions raised. Then the state HOA Oversight Board opened an investigation. Then 3 homeowners filed a separate lawsuit against the board for breach of fiduciary duty. Karen resigned as president 2 weeks later. No statement, just a 1-line email to residents. Effective immediately, I am stepping down from the board to focus on personal matters. But the lawsuit continued, because it wasn't really about Karen anymore. It was about 235 acres, 652 homes, and a ground lease that was starting to look like a house of cards. The second hearing was scheduled. 90 days after the first, Judge Sandoval had read Kim's full report. She'd reviewed the discovery materials. She'd seen the title chain, the payment records, the covenant recordings. She started with a question. Mr. Whitmore, your client has been operating as if it owns this land, issuing fines, threatening liens, claiming control over easements, but the deed is in Mr. Hawthorne's. Name the covenants don't bind his parcel, and your developer client breached the lease terms. So explain to me on what legal basis does the HOA claim any authority here? Whitmore stood, Your Honor. The community was built in reliance on the lease. The HOA's authority flows from that foundational agreement, an agreement your developer breached, the judge said. Minor technical violations that don't justify voiding a 99-year lease and destabilizing 652 homes? That's for me to decide, Judge Sandoval said. What I'm asking is whether the association ever had proper authority to enforce rules on Mr. Hawthorne's property. Because based on the special master's report, it appears they did not. Tried to argue master plan overlay, equitable estoppel, community reliance. The judge wasn't buying it. She turned to Catherine. Ms. Marsh, what's your client seeking? Declaratory judgment that the HOA has no enforcement authority over his retained parcel, Catherine said. Injunction, preventing further harassment. And a determination on whether the lease breaches warrant reformation or termination. And if I find the lease is voidable, then my client regains full control of his land, subject to existing homeowner lot titles. Judge Sandoval sat back. I'm ordering a full evidentiary hearing on the lease breach claims and the scope of HOA authority. I want testimony from Mr. Hawthorne, representatives from Crestwood, HOA board members, and the special master. We're going to settle this properly. She looked at me. Mr. Hawthorne, you understand what's at stake here? Yes, Your Honor. This community exists because you signed a lease. If that lease is void, the legal structure of this entire subdivision is in question. That affects 652 families. So I need to know, what do you actually want? I stood. I want. What was promised? I keep my land. They develop responsibly. No one treats me like a trespasser on property my grandfather bought 60 years ago. Fair enough, the judge said. Let's find out if that's still possible. She set a trial date for months out, and for the first time since Karen Delaney had handed me that first violation notice, I felt like someone was finally asking the right questions, not whether. I was difficult. Whether they'd ever had the right to control me in the first place. The courtroom was standing room only. I'd arrived 30 minutes early and still barely found a seat. Homeowners packed the gallery, some I recognized. Most I didn't. Karen sat 3 rows back, no longer on the board, but still watching like she had a stake in the outcome. She did. They all did. Catherine sat beside me, files organized, notes highlighted. Across the aisle, Whitmore had 2 associates and Marcus Webb himself. First time I'd seen him since our porch conversation. He didn't look at me. Judge Sandoval took the bench at 9 sharp. This is the evidentiary hearing in Hawthorne versus Crestwood Development and Maplewood Heights HOA. We're here to determine the validity and scope of the ground lease, whether material breaches occurred, and what authority, if any, the HOA has over the plaintiff's retained property. She looked at the packed gallery. I know this case affects many of you. I'll ask for quiet and respect. This is a court of law, not a town hall. Whitmore stood. Your Honor, may I address the court? Before we begin testimony, briefly, Your Honor, I want to be clear about what's at stake. This community, Maplewood Heights, was built over 4 years at a cost exceeding $90 million. 652 families live here. They bought homes in good faith, relying on valid agreements and established HOA governance. The plaintiff now asks this court to unravel that entire structure over what amounts to minor technical violations. To unauthorized homes and systematic payment defaults, Catherine interjected. Counsel will wait her turn, Judge Sandoval said. Whitmore continued. If this court voids the ground lease, it creates catastrophic uncertainty. Who controls the streets? The common areas? Utilities? Who enforces community standards? HOA has maintained this property for years. Residents rely on that. Say the plaintiff suddenly owns everything beneath their homes would destabilize the entire community. Mr. Whitmore, the judge said, individual homeowners own their lots. That's not in question. But the infrastructure, Your Honor, the roads, the pond, the clubhouse, are built under the lease. If the lease is void, what happens to those? That's what we're here to determine, Judge Sandoval said. She nodded to Catherine.
What?
Ms. Marsh. Call your first witness. Catherine called me first. I walked to the stand, raised my right hand, swore to tell the truth. She took me through the timeline. My grandfather buying the land in 1967, me inheriting it, the financial pressure, Marcus's offer. Did you understand you were giving up ownership? Catherine asked. Oh, Marcus said. I'd keep the deed, that I was partnering, not selling. Did you approve 652 homes? The site plan showed 650. That's what I signed. She entered the approved site plan as evidence. Then the final plat showing 652. When did you discover the discrepancy? When my attorney reviewed the county records 3 months ago. What was your reaction? I looked at the gallery. The faces of people living on land my family had owned for 60 years. I felt betrayed. I said I'd trusted Marcus. Trusted the process. And he'd built more than we agreed to, then acted like I'd never notice. Whitmore cross-examined, trying to paint me as regretful, opportunistic. Looking for a way out of a deal I'd made freely. You've collected over $2 million in lease payments, haven't you? Yes. And you accepted those payments without complaint for years. I complained when payments were late. Multiple times, but you didn't terminate the lease then. I didn't know I could, I said. I didn't know about the payment default clause or the extra homes until my attorney found them. Whitmore tried to press, but I didn't budge. Catherine had prepared me well. She called Douglas Kim next. The special master walked the court through his findings, the title chain, the covenant recordings, the gaps in HOA authority. The association was granted enforcement power over platted subdivision lots, Kim testified. But the Declaration of Covenants doesn't mention Mr. Hawthorne's retained parcel. The master plan overlay language exists only in the private lease between Mr. Hawthorne and Crestwood. It was never recorded against his deed. Meaning? Judge Sandoval asked. Meaning the HOA has no recorded legal basis to enforce rules on Mr. Eat. Hawthorne's property. They've been operating on assumption and overreach in the lease breaches. Kim detailed them. It's extra homes, 12 late payments for mispayments. Section 12 of the lease states that exceeding approved density constitutes material breach, giving the landowner termination rights. Section 19 states that 3 consecutive payment defaults or 6 total defaults constitute material breach with the same remedy. Has Crestwood met those thresholds? Yes, Your Honor, on both counts. Whitmore tried to downplay it on cross-called. It minor, technical, not rising to the level of voiding a 19-9-year agreement. Kim didn't agree. Contracts have terms for a reason. If exceeding density by 2 units isn't material, what number would be? 10, 50.
Cut.
The lease drew a line. Crestwood crossed it. Catherine called Marcus next. He took the stand reluctantly, sworn in, jaw tight. Mr. Webb, did you build 652 homes on Mr. Hawthorne's land? Yes. Did the lease authorize 650? The approved site plan showed 650. But engineering adjustments during final phases created additional buildable lots. Did you seek Mr. Hawthorne's approval for those lots? Marcus hesitated. No, why not? It was a minor adjustment. I didn't think it required formal amendment. The lease says exceeding approved density requires written consent. Did you get it? Catherine pulled up payment records.
Your company
Missed for lease payments entirely. Is that correct? Cash flow issues during construction. The payments were made eventually. Eventually isn't the same as on time. The lease requires payment within 15 days. 12 payments were more than 30 days late, but weren't paid for 60-plus days. Correct? Approximately. Did you believe those delays were immaterial? Marcus's attorney objected, but the judge overruled. I believed Mr. Hawthorne would be reasonable, Marcus said. Did you believe he'd never checked the plat to see how many homes you actually built? Objection. I'll allow it, Judge Sandoval said. Marcus glared at Catherine. I believed we had a functional partnership. A partnership where you violated the terms and hoped he wouldn't notice. Objection. Argumentative. Sustained. Move on, Ms. Marsh. She did. But the damage was done. Whitmore put up 2 board members and a homeowner who testified about how well the HOA ran, how property values had increased, how the community thrived. None of it addressed whether they had legal authority over my land. Judge Sandoval asked them directly. Did you know the HOA's covenants don't cover Mr. Hawthorne's parcel? They didn't? They'd assumed? Everyone had assumed closing arguments came after lunch. Whitmore went first. Your Honor, this case is about whether we prioritize technical contract terms over the reality of a functioning community. Yes, Crestwood made mistakes. Yes, payments were sometimes late. But the harm here is minimal, and the remedy the plaintiff seeks voiding the entire lease is wildly disproportionate. We ask the court to find that any breaches were minor, that the lease remains valid, and that the HOA's governance should continue as it has for years. Catherine stood. Your Honor, this case is about whether contracts mean what they say. Mr. Hawthorne retained ownership of his land. He granted limited rights under specific conditions. Those conditions were violated not once, but repeatedly. The developer built more than authorized, missed payments, and then allowed an HOA to claim powers it was never legally granted. Plaintiff isn't asking to evict anyone. He's asking this court to confirm what the deed already says. The land is his. Those who've been treating it like theirs need to acknowledge that reality. Judge Sandoval took a 15-minute recess. When she returned, the courtroom went dead silent. I've reviewed the evidence, the testimony, and the special master's report. Judge Sandoval began. This case presents a conflict between contractual rights and practical realities. I'm going to address both. She opened her notes. First, the ground lease. Mr. Hawthorne granted Crestwood Development the right to develop. 650 residential units on 235 acres under specific terms. Crestwood built 652 units. That is a clear breach of Section 12. Crestwood also defaulted on payments, multiple times breaching Section 19. Both provisions grant the landowner termination rights. Whitmore started to stand. The judge raised a hand. However, I'm not going to void the lease entirely. Doing so would create chaos for hundreds of innocent homeowners. Instead, I'm reforming it. The 2 unauthorized lots revert to Mr. Hawthorne. Crestwood will compensate him for the unauthorized use. The lease continues for the remaining 650 lots, but on stricter payment terms. Marcus's attorney looked relieved. Too soon. Second, the HOA's authority. The association has been operating under the assumption that it has enforcement power over Mr. Hawthorne's retained parcel. That assumption is wrong. The covenants don't cover his property. The master plan overlay language was never recorded. The HOA has no legal basis to issue fines, control his driveway, or dictate what he builds on his own land. Karen's face went pale. Therefore, I'm issuing a permanent injunction. The association is barred from enforcing any rules, covenants, or standards on Mr. Hawthorne's 5-acre parcel. He is not subject to HOA governance. Any past fines are void. The courtroom erupted in murmurs. Judge Sandoval gavelled for quiet. Third, the easement. The utility easement along Mr. Hawthorne's property grants access for specific maintenance purposes. It does not grant the HOA authority to control his driveway or restrict his use of his own land. That overreach stops now. She looked directly at me, Mr. Hawthorne. As a matter of record and law, the deed to this land remains with you. It has always remained with you. The lease grants limited development rights, does not transfer ownership, and the HOA's attempt to claim otherwise was legally unfounded. My throat went tight. The association built 652 homes on land they never owned, the judge continued. They've been governing a community on land they never controlled outside the platted lots. That ends today. Individual homeowners keep their properties, those deeds are secure. But common areas, streets, and infrastructure built under the lease are subject to the lease terms, which I've just reformed. If the association wants continued access or control, they'll negotiate with Mr. Hawthorne like any other party. Not as an overlord, but as a neighbor. She closed the file. Judgment for the plaintiff. I'll issue a written order within 10 days. We're adjourned. The courtroom stayed frozen for a moment. Then people started talking. Some angry, some confused. Some like the guy from 3 streets over who'd fought Karen over a flagpole dash grinning dot. Catherine touched my arm. You won. Oh, Whitmore. At Whitmore, at Karen sitting perfectly still, staring at nothing. The judge had just confirmed what I'd known all along but couldn't prove alone. The deed was mine, the land was mine, and 652 homes sat on it. Not because the HOA owned it, but because I'd let them build there. That changed everything. The week after the ruling, I got 43 phone calls. Reporters, homeowners, a property rights advocacy group wanting me to speak at their conference. Marcus's lawyer trying to negotiate the talat compensation before the judge's written order came down. I didn't answer most of them, but answered the one from Angela Patel. She lived on Oakmont Circle, 4 streets into the subdivision. We'd never spoken before the trial, but she'd been in the courtroom every day, taking notes. Mr. Hawthorne, I'm calling on behalf of about 30 homeowners. We'd like to meet with you, if you're willing. About what? About what comes next. She said, the HOA is in chaos. Half the board quit. Karen's gone. No one knows who's in charge or what the rules even are anymore. And frankly, a lot of us are worried you're going to make our lives difficult because of what they did to you. I thought about that. I'm not interested in revenge, Mrs. Patel. And what are you interested in? Fairness, I said. And making sure what happened to me doesn't happen to anyone else. Then we should talk. We met at the clubhouse 3 days later. Angela brought 22 people homeowners from across the subdivision. Some I recognized from the courtroom, others were new faces, no former board members. No Karen, just residents who wanted their neighborhood to work. Angela opened the meeting. Mr. Hawthorne, we know you won. We know you have leverage. But most of us bought homes here because we wanted a good place to raise families, not because we wanted to be part of some HOA power trip. We're hoping you'll work with us. What do you have in mind? A man named Eric, mid-40s, raised his hand. We want a functioning HOA. Someone has to maintain the pool, mow the common areas, organize trash pickup. But we want it to be transparent, fair, not what Karen ran. And we want to make sure we're not living on land where the owner could pull the rug out from under us, a woman named Beth added. She looked nervous. No offense, but the judge said the deed is yours. What does that mean for us? It means your homes are safe, I said. The judge confirmed that. You own your lots? That's not changing. What's changing is that the HOA doesn't get to pretend they own the streets, the pond, or my driveway. So what happens to the common areas? Asked. That's what we need to figure out, I said. We negotiated for 6 weeks. Catherine helped draft a new agreement. I met with the homeowners committee, Angela, Eric, Beth, and 4 others multiple times. The framework was simple. The HOA could continue operating, but only with clear limited authority. The new agreement granted the HOA a revocable license to maintain common area streets, the pond, walking trails, the clubhouse. But it wasn't ownership. It was permission. And it came with conditions. First, financial transparency. The HOA had to publish quarterly financial statements online. Every contract over $5,000 required competitive bids and membership approval. No more backroom deals with board members' spouses. Second, limits on enforcement. Fines capped at $100 per violation. All violations had to be legitimate covenant breaches, documented and photographed. Homeowners got a formal appeals process before any fine became a lien. Third, no authority over my property. The agreement explicitly stated that my 5-acre parcel was outside HOA governance. It couldn't find me, couldn't restrict my vehicles, couldn't tell me what color to paint my barn. Fourth, annual review. Every year, the HOA had to certify compliance with the agreement. If they violated the terms self-dealing, overreach, abuse of power, I could revoke the license and take back control of common areas. This gives you a lot of power, Angela said, reviewing the draft. It gives me the power to stop another Karen, I said. I'm not interested in running your HOA, but I'm also not letting anyone weaponize rules against people who can't fight back. Eric nodded slowly. I can live with that. Beth looked relieved. So we're not losing our neighborhood. You never were, I said. I just needed you to understand it's built on land you don't own. So that means respecting the people who were here first. The membership voted to approve the agreement. 421 to 18. The internal reforms happened faster than I expected. The old board had imploded. Karen resigned. 2 members quit. The remaining 3 called an emergency election. Angela ran for president. Eric ran for treasurer. A retired engineer named David ran for secretary. They won in a landslide. Their first act: rescind every violation issued in the past 3 years and refund all fines. 11 families got money back. Not as many as I'd expected. Turned out most. People had just complied rather than fight. Paid for fence approvals they didn't need. Repainted doors that were already acceptable colors. Moved vehicles that were legally parked. The new board sent apology letters with the refund checks. The previous board overstepped its authority. We're committed to doing better. Their second act: rewrite the bylaws. No board member could vote on a contract where they or a family member had a financial interest. All meetings had to be recorded and minutes published within 7 days. Fines required a majority vote after the homeowner had a chance to respond, and my favorite, they added a clause. The association acknowledges that it operates on land owned by James Hawthorne under a revocable license agreement. All members and board officers shall conduct themselves with respect for the landowner's rights and the historical significance of this property. Angela called to read me that section. Before they finalized it, you don't have to include that, I said. We want to, she said. People need to remember this neighborhood didn't spring from nothing. It has history, your family's history. I didn't know what to say to that. Thank you, I finally managed. The case started showing up in legal blogs within a month. Landowner reclaims authority after HOA overreach. Lessons for developers and associations. Then a state real estate newsletter. When ground leases go wrong, the Maplewood Heights case. A law professor in another state cited it in an article about HOA governance and the importance of proper covenant recording. Catherine forwarded me. Each one, you're becoming a case study. I just wanted to park my truck in peace. She laughed. You did more than that. You proved HOAs aren't untouchable. The ripple effects kept spreading, too. Counties near ours passed ordinances requiring HOAs to disclose all land title and easement structures to homeowners at purchase. Buyers had to be told explicitly whether the HOA actually owned the common areas or was operating under a lease or license. A state legislator introduced a bill requiring financial transparency and capping HOA fine authority. It cited the self-dealing uncovered in my case as justification. I got invited to speak at a property rights conference. Declined. This wasn't about me being a spokesperson. It was about one person standing up when authority overreached. But I did agree to let a local community college use the case in their paralegal program. Catherine Guest lectured twice, walking students through the title chain and what we'd found. What's the main lesson? Student asked her. Read what you sign, Catherine said. And if someone claims authority over you, make them prove it. I ran into Marcus 6 months after the judgment. Hardware store. I was buying fence posts. He was in line ahead of me. We made eye contact. He looked away first. I could have walked past. Pretended I didn't see him. Instead, I stepped up beside him. Marcus. He turned. James, you pay the compensation yet? The judge had ordered Crestwood to pay me $150,000 for the 2 unauthorized lots fair market value plus damages. Marcus's company had dragged their feet, but Catherine had filed for enforcement. Check went out last week, he said. Good. Silence. You cost me a lot of money, Marcus finally said. You cost yourself, I replied. You built what you weren't authorized to build, missed payments you were required to make, and let an HOA harass me using authority you never properly gave them. I thought you'd be reasonable, I was. I let you build 650 homes. I didn't ask questions when you were late on payments. Only pushed back when you tried to take more than you were entitled to. Marcus shook his head. You could have just sold. Me the land? Then it wouldn't be mine, I said. My grandfather didn't buy it so I could hand it to someone who'd treat it like a transaction. He checked out and left without another word. I bought my fence posts and drove home. The neighborhood felt different now. People waved when I drove past. Parents let their kids play near my property line without worry. Few families stopped by to introduce themselves, ask about the land's history, thank me for not tearing everything apart. My wife thought we'd have to move, one man said. When the lawsuit started, she was terrified we'd lose the house. You were never going to lose your house, I said. We didn't know that, he said. All we knew was the HOA told us they were in charge, and then you showed up saying they weren't. It was scary. I understood that. For people who'd bought homes believing the HOA was the final authority, learning the truth had been destabilizing. But now, 6 months later, the fear had faded because the HOA still functioned. The pool opened on time, the grass got mowed. Trash. Pickup happened every Tuesday. The only difference was that no one was getting threatening letters about door colors or fined for parking their work truck overnight. Angela told me violations dropped by 80% under the new board. Turns out most people follow reasonable rules, she said. They just resent petty ones. That was the whole problem, I said. Karen confused power with authority. She thought enforcing rules made her important. She forgot rules are supposed to serve people, not control them. Well, Angela said she's gone, and we're better for it. I sat on my porch that evening, watching the sun set over land my grandfather had bought 60 years ago. 652. One sat on it now. Families, lives, a whole community. Built on pasture where cattle used to graze, it wasn't what my grandfather had. It's envisioned. But I thought he'd understand. The land was still ours. The deeds still had our name, and now, finally, Everyone knew it. Not to fear it, but to respect it the way it should have been from the start. 2 years after the judgment, I found myself sitting across from my neighbor's son in my kitchen. Tyler Chen was 23, fresh out of law school, studying for the bar. He'd grown up in Maplewood Heights, watched the whole case unfold from his parents' house on Willow Creek Lane. Now he wanted to understand it. My property law professor used your case as an example, he said, notebook open. HOA overreach, incomplete title transfers, lease breach remedies, but there's something I don't get. What's that? You had the power to void the whole lease? You could have forced Crestwood out, dissolved the HOA, made everyone renegotiate directly with you. Why didn't you? I poured him more coffee. What do you think I should have done, honestly? Tyler leaned forward. I think you should have crushed them. Karen harassed you. Marcus lied to you. The HOA treated you like a criminal for parking on your own land. You had every legal right to scorched earth them. I did, I agreed. So why didn't you? I looked out the window. The subdivision stretched across what used to be my grandfather's south pasture. Streetlights coming on. Families pulling into driveways. Kids riding bikes in the fading daylight. 'Cause authority without accountability is tyranny, I said. If I'd used my power to punish everyone, homeowners included, I would have been no different than Karen. She wielded rules like weapons because she could. I wasn't going to do the same thing with a deed. Tyler frowned, but they deserved it. Karen did. Marcus did. The old board did. But the 652 families living here, they didn't. They bought homes in good faith. And if I'd voided the lease, just to prove a point, they would have suffered for someone else's mistakes. So you let them off easy. I held them accountable, I corrected. The HOA lost its authority over my property. Karen's gone. Marcus paid damages. The board was replaced. Every homeowner now knows exactly what they own and what they don't. That's not mercy. That's justice that actually works, Tyler wrote. Something in his notebook. My professor said you showed restraint. I showed patience, I said. There's a difference. Restraint implies I wanted revenge and held back. I didn't want revenge. I wanted the system to work correctly. That takes time. It takes documentation. It takes letting the process prove what's right instead of just forcing an outcome. Even when the process is slow and expensive. Especially then, I said, because when you win the right way, it lasts. If I'd just bullied them into submission, they would have resented me forever. Instead, we built something better, an HOA that works, an agreement that's fair. A neighborhood where people understand their rights and their limits. Tyler looked at me. You really believe that? I'm living it, I said. Look out that window. This neighborhood works now. Not because I forced it to, because people chose. The transformation had been slow, but real. Angela's board had served 2 consecutive terms. Eric was running for re-election as treasurer. A woman named Sarah Martinez, a teacher who'd moved in during Phase 5, was the new president. They ran the HOA the way it should have been run from the start. Transparently, fairly, and humbly. Meetings were recorded and posted online. Budgets were detailed and published quarterly. Contracts went through competitive bidding. Violation notices dropped to near zero because the new board focused on genuine issues, safety hazards, structural problems, not petty aesthetic complaints. Pools stayed open. The grass got mowed. The pond was maintained. But no one got fined for parking a work van overnight. No one was harassed for flag colors or mailbox styles. No one lived in fear of clipboard-wielding enforcers photographing their homes at dawn. Had a complaint last month, Angela told me over coffee at the clubhouse. Someone didn't like their neighbor's holiday decorations. Wanted us to cite them for excessive display. What did you do? Told them to talk to their neighbor like an adult, she said. We're not the decoration police. If it's not a fire hazard or blocking the street, it's not our problem. I said why. I said Karen's problem was, she thought, enforcement made her important, Angela said. She forgot she was supposed to be serving the community, not ruling it. I sipped my coffee. You've done a good job. We've tried, she said. But it helps knowing you're not waiting to pull the license if we make a mistake. I'm not looking for perfection, I said. I'm looking for honesty. You mess up, you admit it and fix it. That's all I've ever asked. The case had traveled further than I'd expected, eh? Real estate attorney in another state used it in a seminar on HOA governance. Title company included it in their training materials about verifying authority chains. A state housing commission cited it when drafting new disclosure requirements for planned communities. The bill passed 8 months after the judgment. Now, any HOA in the state had to disclose to buyers whether they actually owned the land or were operating under lease, easement, or license. Developers had to record all transfers of authority clearly and properly. No more assumptions. Catherine called it the Hawthorne Rule. I called it common sense that should have existed already. A podcast about property rights interviewed me briefly. I kept it short. What do you want people to learn from this? The host asked. That authority has to be earned and documented, said, and that when someone claims power over you, make them prove it. Most of the time, they're bluffing. Documentation beats intimidation every single time. The episode got 20,000 downloads. I got emails from homeowners across the country fighting their own HOAs, asking for advice. I forwarded most to Catherine, but I answered a few personally. Same message every time. Document everything. Know your rights. Correct just because they're confident. I had coffee with Eric and his wife one Saturday morning at their house. We sat on their back deck, overlooking the neighborhood park, a 2-acre green space maintained by the HOA under the license agreement. I remember when this whole thing started, Eric said. We were terrified. I thought you were going to shut down the HOA and we'd lose all the amenities. Maybe even our property values. You were never going to lose anything that was actually yours, I said. We know that now, his wife Michelle said. But at the time, all we knew was that someone was challenging the HOA and the board kept telling us you were a troublemaker trying to destroy the neighborhood. What changed? I asked. The trial, Eric said. Hearing the evidence? Seeing the contracts? Realizing Karen and Marcus had been lying or at least bending the truth the whole time. Once we understood what actually happened, it was obvious you were right, and that you weren't trying to hurt us, Michelle added. You were trying to stop them from hurting you. Big difference. I nodded. I could have handled it privately, threatened Marcus, negotiated a quiet settlement, made the HOA back off without going public. But then nothing would have changed. Karen would still be running things. The board would still be self-dealing, and the next person who challenged them would face the same harassment. So you made it public to force reform, Eric said. I made it public so everyone could see how the system works when you don't back down, I said. Documentation. Legal process, accountability. It's not fast, and it's not cheap, but it's the right way. Michelle refilled my coffee. My kids ask about you sometimes. They hear neighbors talk about Mr. Hawthorne, who owns the land. They think you're some kind of landlord. What do you tell them? That you're the reason we have a good HOA now, instead of a bad one, she said. And that sometimes standing up to bullies takes a long time, but it's worth it. I smiled. That's a good lesson. You taught it, Eric said. I was sitting on my porch that evening when a kid rode up on a bike, maybe 10 years old. I'd seen him around the neighborhood but didn't know his name. He stopped at the edge of my driveway, 1 foot on the ground, staring. Can I help you? I asked. Are you Mr. Hawthorne? I am. Are you really the one who owns all this land? He gestured broadly at the subdivision. I smiled. Come here. He walked his bike over. I pointed to the homestead, the 5 acres around it. I own this part outright. Oh, my barn, my land. The rest, I gestured toward the streets. The houses, the common areas, is more complicated. How your house sits on a lot your parents own, that's theirs. The street in front of it, that's part of the subdivision built on land I let a developer use under an agreement. The HOA takes care of it, but they do it with my permission. He thought about that. So you could take it back? Technically, yes, but I won't, because this is everyone's home now. Your family's, your neighbors, mine. My job isn't to control it. It's to make sure the rules are fair. What if someone breaks the rules? Depends on the rule, I said. If it's a real rule, something that keeps people safe or the neighborhood working, then it should be enforced fairly. But if it's a made-up rule designed to control people, then it shouldn't exist in the first place. He nodded slowly. My mom got a letter once about our fence. What happened? The new board said it was fine. It wasn't actually against any rule. The old board just didn't like it. That's the difference, I said. The old board enforced their opinions. The new board enforces actual rules. And if they start acting like the old board, people know they can push back, because that's what I did. The kid grinned. My dad says you're a legend. I laughed. Dad's being generous. I'm just someone who didn't like getting pushed around and knew how to read a contract. Still cool, he said. He got back on his bike. Thanks, Mr. Hawthorne. He rode off, and I watched him disappear around the corner into a neighborhood built on land. My grandfather had walked 60 years ago. The deed still had my name on it, but it wasn't about ownership anymore. It was about respect, fairness, accountability. 652 homes sat on this land not because an HOA claimed it, but because I'd let them be built here under an agreement that finally, after everything, actually worked. The sun set behind the subdivision. Lights came on in windows. Families sat down to dinner. Kids played in yards. A neighborhood that had almost torn itself apart over power and control now functioned the way it should have. From the start, not perfectly, but honestly, and that was enough. I'd fought for 2 years to prove a simple truth. Authority without accountability is tyranny, whether it comes from a government, a corporation, or a homeowners association. The system had worked, slowly, expensively, imperfectly, but it had worked, and now, everyone who lived here understood something. Karen never had. The rules are supposed to serve the people, not the other way around.